Good morning, Sat Sri Akal, Adab. This is my 161th video, and in continuation what I just said, I thank all my friends and my well-wishers after my heart attack how people have supported me. Now I am taking these series to the number of cases and number of files which I had been holding since 2010. Now this is a case of Villette Estate, originally owned by Panna Lal Sud, bungalow number or survey number 96, a property which is only meagerly not even 1 acre, 0.85 acres. This bungalow, after a family division, was sold by one of the co-partners, Mr. Panna Lal Sud. There were 4 or 5 people: Shri Somi Mull, Panna Lal Sud, Hanwant Dass Sud, Dass Sud and Kishori Lal Sud. So this bungalow, very particularly on 16th March 1981, was sold for rupees 35,000 to a bungalow owner through his legal guardians is Mr. Beti, which is on the records. Now what is this bungalow? When these bungalow owners actually transacted the bungalow, it is very important, when went into a transaction of sale, was on hire with the military state officer Ambala. And when it was on hire, this bungalow owner, in the name of which I just said, Somi Mull, Panna Lal Sud, Hanwant Das Sud, Dass Sud, Kishori Lal Sud, on 5th January 1983, gave a resumption notice. At bungalow number 9, Villette Estate, on its north Upper Mall, on its south Inder Villa, east Dunedin Lodge in Inder Villa, and on the west is survey number 102. Originally belongs to Governor General Order 179, 1836, and we are resuming the property. In the next 30 days, you please hand over the property. So the amount of compensation sanctioned was 15,680 rupees. Now this resumption notice itself speaks, in case the amount of compensation offered is not acceptable to you, you are at liberty, if you so desire, to remove the structure so as to leave the land in the same condition which it was before the erection. This is very important, friends. Every resumption notice, way back from 1957 to date, carries this paragraph under the 3rd para or the 4th para. Now this notice also speaks of that. I will talk of it, what benefit you can derive from this statement. The petitioner's father, those are the Sud brothers, letter to MEO on this, bringing him to the notice that the property in question was already sold out to Shri Harjit Singh Beti, being the guardian and the petitioner, and he requested them to withdraw the case or make them the party of the notice. This commune was again uploaded on 1st February 1983. The compensation and everything kept going on like this. So the department was not willing to reply back. Why was the department not? Because the GLR spoke of the Sud family there. And the 1991 sale was without permission. So the present owner, Mr. Harjit Singh Bedi, he went into a writ of number 415 of 1983. And a detailed order was passed in 1984. The court therefore makes the following suggestions to the 1st and 3rd respondent, that is the government and staff. Just and fair compensation should be paid in respect of the superstructure standing on the land which has been resumed. So that the amount of that 13,000 was not just. Such compensation should be determined on the basis of market value as on date of resumption. Interest on the amount should be reasonably paid. So these three clauses were put up. Mr. Bedi had even filed a letter or a policy of 15th November 1977 as an Annexure P15 under clause 2 subpara A, subpara 4, which clearly said what implication, and this letter was detailing about how an alternative plot is to be given, how the calculation of the market, and how an arbitration committee too has to be made. So the court is directing the owner to be compensated. It is clarified that both the aforesaid proceeding, the third petitioner or his duly authorized constituted attorney will be the person who will represent it. So now the court has has said that Mr. Harjeet Bedi will be the man who will sit in the proceedings and not Mr. Sud or Panna Lal Sud. So the new owner is becoming the party in the proceedings of the resumptions when it comes to the entitlement of the compensation. The present application, in the writ, another was filed in 3650/1986. Now in this also, in the light of the material brought on record in the earlier 415/1983 as well in the present proceedings, the effect is Jagjit Singh Bedi and his minors had purchased the property in question from Panna Lal after the partition took place. As aforesaid, the two minor applicants are held entitled to the compensation amount. So that means these two people, after Panna Lal's partition, the registry clerk is directed to some of the guardians of the minor of Harjeet Singh Bedi upon being identified by the advocate K.D. Sood. The payments to be made accordingly, kept in the bank, FDs for these were minors, and so on. So the present, along with the new owner, filed an application in this writ dated in 1988 for an alternative plot. So the High Court said had seek that will apply to the competent authority. So you don't come to the court for it. It has to be through the competent authority. But the applicant, Mr. Bedi, said it has been 1999 and since 1983, no decision has been taken. Repeatedly letters, repeatedly of Villette Estate have been going on. So nothing is happening. Now what does the Solicitor or the Solicitor General of Union of India speaks? Had argued that the petitioners are not entitled to grant of an alternative site as per the extent government policy had reiterated the stand taken in the reply to the effect that Shri Panna Lal Sud, owner, had a number of properties in Kasauli Cantonment. So we need to understand this policy of 77 or the amendment speaks, if you are having a property in the cantonment or within the vicinity of 5 kilometers, you do not get entitlement for 500 square yard plot. But if you don't have one, your entitlement stands. What is the policy saying? Whether the resumptive owner do not possess any other residential plot / house in the cantonment or the adjoining town or city or notified area, they may be provided on freehold basis alternative developed site not exceeding 500 square yards, in each case on payment of 50% of market value. This would be subjected to the conditions under ULC and everything, and resumptives and conditions, each cantonment. So that 15th November 1977 policy speaks. So what is the argument? This court is of a firm view that the petitioners have not been treated in a just and fair manner, and the respondents have taken arbitrary decision while declining the request of the petitioner for providing alternative. The petitioner father, in his representation dated 4th April 1988, has also given instances of 4 properties where Union of India regularized the sales made without the prior permission of competent authority. This is very important evidence to all those bungalow owners who have been in illegal occupation, what the department says, because of their sales without permissions. N number of judgments were told: AIR 1952 Supreme Court, AIR 1960 Supreme Court 707. All these judgments speak of rights, what is the executive to do, can he behave in a discretionary manner, arbitrary manner. This is all. So basically the backdrop is evident. The court is trying to influx an executive duty that please, this policy is there, why don't you entertain this 500 square? Has to issue appropriate directions. The court even goes down to extent saying the respondent to meet the end justice, equity and fair play. In normal circumstances, the court could have issued a writ of mandamus directing the respondents to take a decision as per memorandum dated 15 November 1990. But in view of the facts of this case, as projected above and the case law, the court do not completely justify is required to issue a writ of mandamus directing the respondents to allot alternative sites after resumption 5th January 1983. Consequently, in viewing the above observations made here and above, the writ petition is allowed, RX 1986 squashed, and the petitioner within 8 weeks from today will be given an alternative site. Can you imagine in this case, the Union of India has been fined 10,000 rupees in 2007. But what is happening? I checked up with the present DO Ambala. She doesn't want to share those papers with me. She showed me that nothing has happened, no alternative plot has been given. They don't want to compensate you. Please try and understand. After this accession, things are going to be very bad for OGBs. You people will first run for ownership, then next 40 years you will run for alternative plots and good compensation. 2 generations will move out during this period. Please wake up your eyes. I am only trying. I really can't do anything. I'm trying and I'm continuously trying for the last 15-20 years. So why don't you people understand? Please, this is a wake-up call. I don't want to get into the nitty-gritties of Mr. Bedi and Mr. Panna Lal Sud and who's he, who's who. This case of Vivlette is so important, and Kasauli bungalow owners should get together, dig into everything what has happened to this case and the compensation given. Because this bungalow, actually they know what is it. Please wake up. We are old grants, never converted into new grants because we were revenue free grants. Thank you.